就我哋咧呢個
Members, this is a meeting of the Subcommittee on Financial Institutions Resolution Protector Arrangement Regulation and Financial Institution Resolution Ordinance Commencement Notice 2017. This is the first meeting. Let's elect a chairman. I nominate Mr. Chen Chen-ying, seconded by Mr. Wong Ting-kwong. Mr. Chen, do you accept the nomination? Yes. Do we have another nomination? No other nomination, so Mr. Chen Chen-ying is elected as chairman.
早上各位，咁而家我哋不如先請。
Good morning. Do we need to elect a deputy chairman? No need. Okay. Please invite the officials to join us.
佢哋係邊個負責講啊？秘書長定係跟住 Mr. Wright 係嘛 ？Mr. Wright，OK。早晨，歡迎各位啊
Good morning. Welcome. According to the agenda, we will invite the official to give an introduction. Ms. Kwok. Thank you, Chairman. First of all, we would give an introduction to the Financial Institution Resolution Ordinance. Here's some background information. Since 2007, EU and US have faced severe financial crisis, just like Asia did in the previous decade. And the ordinary insolvency proceedings were found to be unsuitable to deal with such a crisis. So the G20 leaders mandated the Financial Stability Board to address the too big to fail phenomenon. The Financial Stability Board, FSB, member jurisdictions committed to establish effective resolution regime consistent with standards set by the FSB's key attributes of effective resolution regimes for financial institutions, which set out those powers that authority should have to be able to deal with the failure of a systematically important financial institution. Turning to the commencement notice. The ordinance, the FIRO, was passed by LegCo in 2016, establishing the legal basis for cross-sector resolution regime to comply with the key attributes of FSB, so that necessary powers are given to the authority to effect orderly resolution of a failed, systematically important financial institution. In a moment, our colleagues from the Hong Kong MA would say something about the commencement notice. With the commencement notice, the FIRO would take effect on the 7th of July 2017. This would enhance our resilience as a major international financial center, as well as enable us to comply with international standards by the FSB's key attributes. Turning to the contents of the protected arrangement, I will defer to my colleagues from Hong Kong MA.
You would like to give us some background about this bill, right?
Yeah.
Thank you. Please go ahead.
So, under Section 75 of the FIRO, the Secretary for Financial Services and Treasury may make regulations as subsidiary legislation to safeguard the economic effect of certain financial arrangements termed protected arrangements in resolution. There are 6 types of financial arrangements identified as protected arrangements under Section 74 of the FIRO. They include clearing and settlement system arrangements, netting arrangements, secured arrangements, set-off arrangements, structured finance arrangements, and title transfer arrangements. And given these will be important throughout the rest of our session, I'll just give a brief description of each of those arrangements to help the discussion. So a clearing and settlement system arrangement means an arrangement governed by the rules and directions relating to participation in the clearing and settlement of transactions within the financial market infrastructure. So very simply, this is the financial plumbing through which payments are made and transactions settled and cleared. Our objective is not to disrupt these, and this is important to prevent contagion and wider financial instability from resolution of a participating member of a clearing and settlement system arrangement. A netting arrangement means an arrangement under which a number of claims or obligations can be converted into a net claim or obligation. Set-off and netting arrangements are important to financial institutions as they allow regulatory capital requirements to be based on the net exposure under the arrangement. Without being able to do this, capital requirements would be much larger as they would have to be based on a gross exposure. Secured arrangements mean an arrangement under which a person acquires by way of security an actual or contingent interest in the property of another. An arrangement under which creditors seek to protect themselves against credit risk through taking charge over an asset or assets belonging to the debtor. A set-off arrangement means an arrangement under which 2 or more debts, claims or obligations can be set off against each other. A structured finance arrangement means an arrangement under which a person creates and issues an instrument under which some or all of the returns or amount due or the method of settlement is determined by reference to price, value or parameters, or the changes in the price, value and parameters of financial assets or the occurrence of non-occurrence of specific events and include asset-backed securities, securitizations, asset-backed commercial paper, residential and commercial mortgage-backed securities, and collateralized debt obligations and covered bonds. And finally, title transfer arrangements means an arrangement under which a person transfers assets to another person on terms provided for the other person to transfer assets if specified obligations are discharged. These include in particular reverse repurchase transactions or obligations. So that's just a high level of overview of what these regulations tend to protect and define as protected arrangements. These regulations provide certainty on the treatment of these arrangements, and this is important because financial market participants rely on these protections as risk mitigation tools and as sources of financing. So, protected arrangements regulation is designed such that the RA, or the Resolution Authority, should exercise powers in a manner that safeguards the economic effect of a protected arrangement in resolution. Ultimately, this creates restrictions on the Resolution Authority's use of powers with respect to the 6 types of financial arrangements I've just described. The risk of economic effect of protected arrangements being undermined is most likely to occur where a partial property transfer is made by the Resolution Authority, or where a bail-in, where liabilities are written down or converted without taking into account linked assets or rights entitled to be set off or netted under documented agreements. The proposed approach to the PAR is largely modelled on that adopted by the United Kingdom and that required by the European Union's Bank Recovery and Resolution Directive. The PARs provide the appropriate degree of protection for each type of protected arrangement with specific carve-outs for certain rights and liabilities under certain arrangements designed to provide 1. confidence for financial market participants that critical risk mitigation and funding techniques will be protected with certainty and predictability in the event of a resolution. And two, while at the same time provides an appropriate degree of flexibility for the resolution authority to exercise resolution powers in order to achieve orderly resolution consistent with the resolution objectives. The powers also provide for appropriate consequences in the unlikely event that inadvertent action by the resolution authority results in asset rights and liabilities that are part of protected arrangements being treated inconsistently with the objectives of the protected arrangements. On public consultation, the Financial Services and Treasury Bureau, the HKMA, the Insurance Authority and the SFC jointly conducted a 2-month public consultation which began in November and ended in January on the proposed approach to protected arrangements regulation. We engaged with key stakeholders during the consultation period and received 11 submissions from industry, professional bodies and financial market infrastructure. Broadly speaking, respondents generally agreed with the approach to the regulations, was providing constructive and some technical minor points of feedback which we've taken into account in development of the final regulations. Thank you.
好，政府嗰邊仲有冇咩？
Anything from other officials? So the floor is now open for members to raise questions. Mr. James Toe. So 6 categories, 6 types of financial arrangements are protected, and the regulation is supposedly not to expand into any area beyond the 6 already set. That is to say, clearing and settlement systems, letting, secure arrangements, so on and so forth. We're not going to expand beyond these 6 types. So my simple question is this. Under the regulations, what would be handled as by the FIs as unprotected arrangements? Let's say I have a deposit in a bank. Can I lose everything after the resolution?
On to the question is, these regulations specify a set of restrictions on the resolution authority when they apply their tools in the event of a future bank failure. And by identifying the 6 financial arrangements which we define as protected arrangements, it provides certainty to those arrangements that on their treatment by the resolution authority in the event of a resolution. So we make clear here that those arrangements will not change or be impacted by the use of the resolution tools. This is important because these arrangements, these financial arrangements, provide very important risk mitigation protection to financial institutions and are important for funding markets. There are some specific carve-outs which we'll go into more detail when I step through the regulations to the protections provided to those financial arrangements, and they're largely designed to achieve 2 objectives. The first one...
Chairman. Well, I think this is too broad. I was a member of the Bills Committee on the FIRO, but I think you need to explain in simple terms. Say, I have $100 as a deposit in the bank, and then in a big crisis, there's a need to have a resolution or to have a reorganization. Will my $100 be lost?
Reply exactly to the concrete queries raised by Mr. Toh. He would like to know, to quote the example about the deposit owned by any customer of a bank. So please give him, the consequence after the regime has been taken in effect.
And I also hope that the FSTB can respond to the same question. Well, I don't have any discrimination against rich people, but you know that most of our people are not rich people. And I can just give you an example.
Say, it will not affect the protected deposits. Is it $500,000? Yes, $500,000. Say if you have just less than $500,000 deposit, the resolution mechanism will not affect the deposit. Well, you may say that if there is no such a mechanism, your deposit will not be protected. But I have to be very serious about it. That's about the deposit that are protected. Well, if the deposits are not protected, then people will not trust the bank. Say, I'm not going to put my $500,000 in the bank. Maybe I have to keep some of the money in my home instead. I know that you consider a broader issue, a greater public interest. But if there is something which doesn't have any exception, then I have to think about the interests of the mass. Because of this resolution regime, people will not trust the bank. And people will have to find a way to save their money. Now, you don't, as for safe deposit boxes, there is no netting. So I will put my money, turn my deposits into cash, and then put it in the safe deposit box of the bank. I can pay, say, $1,000 a year for the safe deposit box in the bank because my deposits will not be netted in the in the resolution regime. I hope you can explain your arrangement from the perspective of the small depositor. And the purpose of the FIRO is to protect critical financial functions of the bank, including deposits. Now, in this FIRO regulation, we have a special arrangement for deposits. As for the technical side, I'll ask the MA representatives to explain. This is a very critical function, and we hope that it will not be affected. Say, if it is transferred to a purchaser, the function will be transferred as well. The depositors will not be deprived of their deposit simply because of the transfer. Maybe Mr. White can explain the technical side. Which part of the regulation are you referring to?
Under the FIRO, the primary legislation, deposits are protected. The primary objective of a resolution, whether it's a transfer or a bail-in, is to ensure continuity and access to the deposits. So if we would transfer the deposits to a bridge bank or to a private sector purchaser, and therefore the depositor would continue to have access to their deposit funds. That is the primary objective of the resolution. In a bail-in, deposits are protected up to the deposit protection scheme limit, which is $500,000. So that amount is completely guaranteed.
Chairman, can you explain to me under which part of the regulation there is such a provision so that I can explain to the public? Mr. Wright, I think Mr. Toh is asking about this deposit whether there is any specific provision that will not affect the right of depositors, and the deposit protection scheme still works. If possible, just write half a page and explain it to us in black and white. I have asked this question and you have answered this in this way, just for the record. Maybe the legal advisor can also help us out. Which provision in the regulation as a whole protects the deposits? under the deposit protection scheme. Those who have less than $500,000 of deposit at banks do not need to convert their deposits into cash and put them in the safe deposit box. Mr. White, perhaps you can give an oral reply, and then afterwards you give us a written reply.
The protections are provided for in the Financial Institutions Resolution Ordinance, the primary legislation, under Part 4 or Part 1, Section 11. That specifies the protection provided to deposits. So it's more in the primary legislation, which is not specified in this subsidiary legislation, and we'll provide that clarification in writing afterwards as well.
There is another technical question. This is final one, and I have to go. Now, during a crisis, now there is a transfer. Say a bank. The bank has a problem. You may need to form a vehicle to take over the deposits in order to protect the depositors. Now, since it is a bank, then under the deposit protection scheme, I am protected because of the mechanism. But now you transfer this to a vehicle or a company. This is not a bank. Now, I had a sum of money. Or rather, there is a debt with that company. And in another crisis, that vehicle or company also goes under. So these cannot be resolved. So in the first crisis, I had the protection because of the deposit. But when there is a transfer, it's transferred to a vehicle, it's not a bank, then this is not a bank. So it becomes a debt. And there is a moratorium. I cannot get money back because of the crisis. But after 1 month, there is another crisis, and then the vehicle goes under. Since it is not a bank, the vehicle is not a bank, the money is not deposit, I have become an ordinary creditor. Will that situation occur? Can you explain, say, in half a page, if there is any protection, if anything untoward happened to that vehicle? Well, now, my understanding is this. Now, Mr. Toh asked this question. Now, say, suppose a bank has a problem. You have to start the resolution regime. The deposits will then be transferred to a bridge vehicle or a temporary public company. And then if there is a second crisis, will this vehicle therefore collapse? And the deposits that should have been protected will no longer be protected because that vehicle is no longer a financial institution. Will that occur? That's a question of Mr. Toh. And will there be any protection? Now, apart from an oral reply this morning, he also asked for a written reply for the record. And if need be, if there is no adequate protection here, then you may need to have consequential amendments to amend the Deposit Protection Ordinance to deem that company or that vehicle as a bank. Maybe let us listen to the HKMA whether they have already taken that into account. Mr. White.
That in a couple of simple statements, the transfer of the deposits to a bridge institution, the bridge institution would be an authorized institution. It would be a bank, and it would have to comply with all the same statutory and regulatory obligations as an authorized institution as regulated by the HKMA. And any deposit that would be in the bridge institution would have the same protections that it always had under the Deposit Protection Scheme.
但係 Mr. Wright 喺文件第6段嘅 E 嗰度都講咧。
Under paragraph E, it's also said that it can be transferred to a temporary publicly owned company. Is it regarded as an authorized institution as well?
To the temporary public institution, publicly owned institution.
會唔會嘅意思就係話無論專
So whether it's transferred to any bridging institution, whatever form the bridging institution is, it is deemed to be an authorized institution. Am I correct to say so?
One further point. The bridge institution and the temporary public company would need to comply with minimum conditions for authorization, including capital and funding requirements. And it would then be the responsibility of the authorities to ensure that the firm was always in compliance with those minimum conditions for authorization.
Now my question is not here. Now, even if, said by the chairman, now it is a bridging institution. Say the requirement of the bridging institution is similar to those of the bank. That's not the point. I'm talking about the deposit protection scheme. Now, if the deposits are transferred to the bridging institution is covered by that deposit by the deposit protection scheme. Even at that second, the institution, the bridging institution, has no bank license under the deposit insurance deposit protection scheme. The deposits are still protected because the institution is assumed to be a bank under the deposit insurance scheme. I think this point is rather technical, and I hope our legal advisor can also look at it from the legal point of view. Mr. White, do you have anything to add?
Reiterate that deposit protection scheme protection for deposits of a failed bank that was transferred to a bridge institution or a temporary public ownership company would still benefit from the same protection of the deposit protection scheme.
If I may ask the question, once again, now all the bridging institutions are deemed to be an AI. But Mr. To's point of view is that under the deposit protection scheme, in respect of the in respect of the resolution scheme, the institutions arising from the resolution regime being covered by the deposit protection ordinance. I think Mr. To's concern is whether there are provisions in the deposit protection ordinance. The definition of financial institutions does include the bridging institutions.
But I think that's a review about the technicalities to see whether we have covered all the technical points by which the deposit protection scheme or ordinance can trace or can follow or deem that the new temporary institution, although may be deemed by this ordinance FIRO to be an authorized institution, but whether according to that deposit protection ordinance would deem that new AI under this FIRO would be an AI under that ordinance.
Yeah.
Sorry, a little bit clumsy.
Yeah. 我諗好清楚啦，杜委會。
I think Mr. To's point is very clear.
跟進一下嘅。
I think we need to follow up on that after the meeting. Mr. Chen Kim-po. This would affect both banks and insurance companies. You have provided a summary of the consultation exercise. 11 submissions were received. For things that you have agreed to or amended, I have no comment. But have you rejected any of the submissions, especially those from the insurance sector?
Mr. Wright?
I'll pass over to my insurance sector colleague in a second to offer any additional points. But I think as set out in the presentation, industry was broadly supportive of our approach to protected arrangements, and the nature of the comments that we received as part of the consultation feedback were largely around clarifying definitions and clarifying the scope of the protections provided to the arrangements that we've described. So, for example, as a result of the consultation feedback, we've refined our definition of financial contracts, and we've provided more examples of to accompany our description of clearing and settlement systems, but very much in this refining feedback. And
保險方面啊，Tony 有冇咩講？
Anything from the insurance sector, Tony? Here we are talking about the protection for various financial instruments. We don't receive anything substantial from the insurance sector. Have you received inquiries further to the consultation from the banks and insurance companies? Can I come to the conclusion that there will be no implementation problems? Well, you may say that. All right. If there are no further questions from members, do we need to invite deputations? I don't think so, because I believe my sector doesn't really have a lot to say about this. Perhaps we can now do the cross-by-cross examination now. Who would do this with us? I will be doing the commencement notice, and then we'll move on to the protected arrangements, regulations, and that will be done by my HKMA colleagues. All right, please start, Ms. Kwok. It's Financial Institutions Resolution Ordinance Commencement Notice 2017. This is the notice from the Secretary for Financial Services and the Treasury, who appoints the 7th of July 2017 as the day the May provision will come into effect. But there are some exceptions. Part 8, Section 192. The notice on winding up intention, and also Division 10 of Part 15, Sections 223. We have consulted the judiciary over Part 8. The Chief Justice would come up with rules in accordance with 145, Rule 145 and 8, and then Part 8 will come into effect. For Section 192, unless the petitioner has issued a notice to the resolution authority, he cannot file a petition to the court of first instance to wind up an FI or the holding company of an FI. After consultation with the judiciary, we believe that this section should come into effect. After the Chief Justice has come up with rules regarding Section 192(5). As regards Part 15, or Division 10 of Part 15, Section 228 to 232, and that is the amendments to the 2015 the Insurance Amendment Ordinance. And this is related to the second stage provisions. And that is when we have the independent insurance authority taken over from the provisional one. Then if we commence before that, those sections will be necessary, will be needed. But since the independent IA will take over before on the 26th of June, which is before the 7th of July, so that's why those provisions are accepted. So, members, questions? No. All right, let's have the second part of the cross by cross.
Of the regulation to explain how it is designed to operate. Part 1 provides for the commencement of the regulation and the interpretation of defined terms. Section 1 provides that the regulation comes into operation on a day specified, which Part 5 of the FIRA comes into operation, which, as previously discussed, is proposed to be the 7th of July. The coming into operation of the regulation is tied specifically to Part 5 of the FIRA, as Part 5 provides for the operative powers, the stabilisation options, bail-in, transfer, etc., in respect of which PAR establishes the appropriate constraints on the resolution authority. Pursuant to Section 31(1) of the Interpretation and General Clauses Ordinance, expressions used in the regulation have the same meaning as in the Ordinance conferring the power, i.e. the FIRO. Section 2 sets out specific definitions used only in the regulation, certain of which can only be properly considered in the context of the relevant provisions of the regulation in which they are used, namely financial activity, financial contracts and transferable securities. The primary use of these definitions is in the context of defining appropriate exclusions from certain protections under the regulation to ensure that the resolution authority has the appropriate degree of flexibility to secure an orderly resolution in the event of FI failure. The two more substantive definitions in Section 2 are of protected clearing and settlement system arrangements and protected structured finance arrangements, which make reference to Section 3 and Section 4 respectively. These definitions specify the classes of clearing and settlement system arrangements and structured finance arrangements to which this regulation applies, as permitted by the empowering provisions in the FIRO. Protected clearing and settlement arrangements is defined in Section 3(1). The definition covers certain specified arrangements that are governed by the rules and directions relating to participation in the clearing and settlement of transactions within a designated clearing and settlement system or a recognised clearinghouse. The specified arrangements listed in Section 3(1) are those protected by the insolvency override in Section 21 and 45(1) of the PSS VFO and the SFO respectively. The policy objective here is to prevent resolution actions from disrupting the operation of payments, clearing and settlements. Section 3(2) provides for the interpretation of a number of terms used in the definition of specified arrangements above in Section 3(1) by reference to defined terms in the SFO or the PSS VFO. This is necessary because these terms are defined separately in the SFO and PSS VFO. Section 4(1) provides a definition of protected structured finance arrangement, making clear that the definition covers securitizations, whether established through a true sale or synthetically. This broad description is designed to capture arrangements created through real or synthetic transfer of assets, such that assets operate in as security against notes issued to investors from securitization vehicles, for example, asset-backed securities, asset-backed commercial paper, mortgage-backed securities. Section 4(2) establishes that any role of an originator in a true sale securitization is to be treated as a liability forming part of a protected structured finance arrangement. The objective here is to make sure that key roles that an entity in resolution plays in securitization, beyond simply the underlying assets and notes issued against them, are covered by the definition, so that they should not be split apart by a resolution authority in the event of FI failure. Section 3(4) clarifies that for a synthetic securitization, a security interest is only to be treated as part of the arrangement if it is attached to a specific and sufficiently identifiable asset. This means that to be recognised as a protected structured finance arrangement, the pool of assets backing the notes issued under the synthetic security must be clearly identifiable, and the security interest under the arrangement clearly linked to those assets. Section 4(4) further provides that, in the case of both true sale and synthetic securitizations, agreements constituting a securitization structure covering mutual relationship between the key players in the structure, e.g., for example, the originator and the issuer, trustees and the servicers for those vehicles, are to be treated as forming part of the protected structured finance arrangements if those relationships are directly linked to the relative underlying assets or payments to be made from their proceeds to note holders. The objective here is to make sure that the key roles that an entity in resolution plays in a protected structured finance arrangement, for example as a swap provider or as a trustee or a mortgage servicer, are covered by the definition to ensure that those services continue in resolution. Part 2 of the regulation establishes what a resolution authority is to seek to do when making a regulated Part 5 instrument that transfers assets, rights or liabilities as appropriate to the specific arrangement that are or form part of different types of protected arrangements. And just briefly to recap, a Part 5 instrument is defined in Section 74 of the PAR as resulting in partial property transfer being effected or contains a bail-in provision. A Part 5 instrument is defined in Section 2 of the FIRO as any of the following. First, a security transfer instrument. Second, a property transfer instrument. Third, a bail-in instrument. Part 2 of the PAR addresses what a resolution authority is to seek to do in the context of the partial property transfer. So in that part, Section 5.1 provides that where a resolution authority is making a regulated Part 5 instrument, transfers rights or liabilities that are part of a set-off arrangement, netting arrangement or title transfer arrangement between the transferor and a person, then the resolution authority is to seek to transfer all the rights and liabilities under that arrangement, not just some of them. The policy objective is to provide certainty that important set-off and netting rights are afforded an appropriate degree of protection in resolution by preventing a resolution authority from cherry-picking favourable contracts under such an arrangement, given that set-off and netting are relied upon by financial institutions and their counterparties to mitigate risk and to lower capital costs. Section 5.1a establishes that set-off and netting or title transfer arrangements must be documented or otherwise evidenced in writing, and this avoids the disproportionate constraints on the use of resolution tools. Section 5.1b clarifies that either the transferor or person under the arrangement is entitled to set off or net for the arrangements to qualify for treatment under Section 5.1. Section 5.1c reflects the policy intention that clauses entitling a non-defaulting party to make no or only limited payments, even where the defaulting party is a net creditor, are not afforded protection, given that such clauses are not regarded as valid bilateral netting agreements for the purposes of banking capital rules. Section 5.1d provides that the rights and liabilities under 5.1 must first arise out of the arrangement, that is, they must not arise from broad set-off clauses that extend to any or all relationship between a counterparty and the financial institution, rather than those specific to the arrangement. Capturing such clauses would severely restrict a resolution authority's ability to achieve orderly resolution by separating out the failed institution's critical financial functions sufficiently quickly and decisively. Second, not be excluded under Section 5.2. The rights and liabilities under Section 5.2 are intended to be those that a resolution authority would need a high degree of certainty that it could transfer quickly and decisively to secure the continuity of critical financial functions, for example deposits, or that it could leave behind in a residual entity to absorb losses as appropriate, examples being subordinated debt or transferable securities, irrespective of any link to a set-off or netting rights. These rights and liabilities are as follows. Rights and liabilities relating to a deposit made with the transferor, rights and liabilities relating to assets in the form of receivables owed to the transferor by depositors, rights and liabilities relating to subordinated debt, and rights and liabilities relating to transferable securities as defined in Section 2. Mm-hmm. The exclusions for subordinated debt and transferable securities are to provide that equity, junior debt and unsecured debt liabilities can be left behind in a residual entity to absorb the losses that cause the FI's failure. This reflects their position in the creditor hierarchy and the policy objectives to ensure losses are absorbed in resolutions consistent with how they would have been in a liquidation. Moving on to Section E, rights and liabilities arising under a contract entered into by or on behalf of the transfer or otherwise then in the course of undertaking financial activity, which is defined in Section 2. This exclusion is to provide flexibility to the resolution authority such that operating liabilities relating to the undertaking of critical financial functions, for example deposits, can be transferred to support the continuity of access to those operations. And finally, rights and liabilities arising in connection with the undertaking of financial activities relating to the claims for damages, an award of damages, or a claim under an indemnity. Recognising the need for these specific carve-outs, it does not impact the no creditor worse off in liquidation compensation protections that still are available to all pre-resolution shareholders and creditors. So that's just important to bear that in mind. Section 6.1 provides that a resolution authority in making a regulated Part 5 instrument transferring any constituent part of a secured arrangement is to transfer the arrangement together in its entirety. This means that assets and rights under a secured arrangement should only be transferred to if the liability and benefit of the security are also transferred. And the benefit of the security should not be transferred unless the liability is also transferred and vice versa.
Okay. Mr. Wright,
yes.
May I suggest, because I suppose all our members has thoroughly reviewed all the detailed terms and conditions of the proposed bill. So you might, introduce the detailed content by section. That means you shouldn't or you need not to read out all the detailed provisions thereon. Instead, you can give us a heads up on each particular section instead, so that we can, raise questions even when we think appropriate. Okay? Thank you.
Yeah,
Thank you, Mr. Wright.
I'll go a little bit more quickly. So, Section 2 provides that the resolution authority, irrespective of whether the secured arrangement is established using a fixed or floating charge, that also is provided for under the protection. Section 6.3 provides that a resolution authority is required under Section 1 does not apply where purported secured arrangements has been made in contravention of any legal restrictions, so this under the banking ordinance. So that's another important point to bear in mind. Section 7.1 provides that in making a Part 5 instrument which transfers assets, rights and liabilities, protects the structured finance arrangements. Section 7.2 provides that deposit liabilities of an entity in resolution that are part of a protected structured finance arrangement are not subject to what a resolution authority is required to do under Section 7. So this means that the resolution authority can transfer any deposit liabilities separate from the secured arrangement. So this is one of the specified carve-outs. Section 8.1 provides that defines the protection for clearing and settlement system arrangements. The main point here is that everything needs to be transferred together or everything needs to be left behind together. Section 8.2 then sets out a list of non-exhaustive examples to help further reflect consultation feedback that we received and clarify the definitions that we're using in the regulation. Section 9 establishes where a regulated Part 5 instrument purports to transfer foreign property that is set off, part of a set-off netting and title transfer, or secured or protected structured financial arrangements. The resolution authority has not acted inconsistent with the objectives of the PAR if a foreign court were to restrict the transfer of that foreign property. So the key point here is that over time, by engaging with foreign authorities, we would hope that the risk of such action by a foreign court would be reduced. Section 10, 11 and 12 establish the consequences, however unlikely, should a resolution authority inadvertently act in a manner inconsistent with the objectives of Part 2. As I've mentioned in the overview presentation, whilst it is considered necessary to provide for consequences in the event that a resolution authority takes an inadvertent action, we think that the resolution planning powers provided to the resolution authorities on switch on of the FIRO will reduce the risk of inadvertent action. And also, as we engage with financial institutions as part of resolution planning, the development of by those institutions of information systems capable of identifying protected arrangements quickly and with a high degree of certainty will also further reduce the risk of any unintended inadvertent action that results in the need for consequences. However, those consequences are spelled out in section 10, 11 and 12. And very briefly, under section 10 it provides the rights of a person to set off a netting with a transfer under a set-off netting and title transfer arrangement is not affected by action taken by the resolution authority that is inconsistent with what a resolution authority was required to seek to do. Section 11 provides for an affected party's position under a secured arrangement or under a protected structured finance arrangement to be restored if there is any inadvertent action, either through a supplemental or a reverse transfer of assets or liabilities. And Section 12 finally provides for the transfer to be void to the extent that it disrupts the operation of a clearing and settlement system arrangement. So moving on, Part 3 of the regulation establishes what a resolution authority is to seek not to do when applying bail-in stabilisation option. Section 13.1 sets out the definitions specific to this part. I refer back to these as part of the relevant operative provisions, but briefly, Section 13.2 lists the liabilities excluded from the definition of protected liabilities. Section 13.3 clarifies for the purpose of the definition of protected liabilities that an arrangement that can be permitted to set off a netting with more than one counterparty, and that it does not matter whether the rights to set off or net is only exercisable under the occurrence of a particular event. So Section 13.3 explains how a liability is to be treated as if it had been converted into net debt, claim or obligation, which is relevant to the purposes of this section. Section 14 is an important section as it provides that the resolution authority is to seek not to make bail-in provisions in respect of a protected liability, and it spells out the definition for protected liability in Section 13.1 as a liability that A is owed to a third party by an affected party. B, the third party or the entity are entitled to set off and net under a set-off netting and title transfer arrangement. C, if related to the financial contract, has not been converted to a net debt or claim or obligation. And D, if related to a contract of any kind, has not been converted or treated as if it had been converted into a net debt or claim. C and D ensure that financial contracts falling within the definition of in Schedule 1 must be converted per the terms of the relevant set-off netting or title transfer arrangement into a net position before they can be subject to bail-in. This is consistent with sort of the general feedback we receive from industry, particularly in the context of derivatives. So this is a very important provision for orderly bail-in and as it applies to these contracts. Moving on, under Part E, this definition of liabilities is not excluded by Section 2. So this is the liability under Section 2 are those liabilities that it is considered will represent good forms of loss-absorbing capacity on which losses would be expected to be imposed in a bail-in execution. And examples of these liabilities are as follows. A liability owed in relation to a capital instrument issued by the affected entity. A liability owed in relation to subordinated debt issued by the affected entity. A liability owed in relation to unsecured debt instruments. An unsecured liability in relation to any instrument or contract with a maturity period of 12 months or more at the point of issuance, and that is not a financial contract. And an unsecured liability owed to the group company of the affected entity. A liability in relation to a deposit that is not excluded from the bail-in pursuant to Section 2B and C of Section 5 or Schedule 5 of FIRO, and finally a liability in relation to a claim for damages. Section 14.2 provides that notwithstanding a liability being protected a resolution authority is not prevented from exercising bail-in provisions pursuant to Section 58.3c of FIRO to convert or in connection with converting the protected liability into a net debt, claim or obligation or an estimate thereof such that it can be subject to bail-in consistent with the objective of Section 14.1. It is, however, recognised that the authorities, by the authorities, that closing out such positions quickly at the point of failure may have material valuation and continuity complexities, and therefore decisions on whether to close out such provisions would be made on a case-by-case basis. And importantly, over time, as local loss-absorbing capacity requirements are developed and set for institutions, this should reduce the need to rely on the closeout of net liabilities as a source of adequate loss-absorbing capacity. Section 15 establishes, again, consequences should a resolution authority inadvertently act in a manner inconsistent with what is required to seek not to do in Section 14.1. In short, in the event that a resolution authority inadvertently makes bail-in provisions in respect of a protected liability, it must seek to take steps to transfer to the affected party a required sum as defined in Section 13.1. Exactly how the required sum is to be transferred depends on whether bail-in has been effected in conjunction with a bridge bank, but ultimately requires a resolution authority to take action to provide shares or a payment by the relevant entity of an amount equal to the required sum. Section 15.8 to 15.11 impose time limitations on the resolution authority as part of the consequences. And again, just to repeat, the no creditor worse off and liquidation protections still apply to pre-resolution shareholders and creditors as part of executing the bail-in resolution. And finally, as mentioned earlier, Schedule 1 sets out a list of financial contracts for the purpose of, firstly, the definition of financial activity, second, the definition of protected liability, third, rights and liabilities excluded under Section 5.2 for the objective of the regulation in respect of set-off, netting and title transfer arrangements in a partial transfer. 4, liabilities excluded from the definition of protected liabilities in the context of a bail-in. These contracts are securities contracts, commodities contracts, derivative contracts, and contracts for purchase, sale or delivery of currency and master agreements so far as they relate to any of these contracts. Thank you.
Mr. Wright. Go ahead.
Thank you, Mr. White. Do members have any questions concerning the specific provisions? No? Well, we do have some other items. Now, concerning the 2 written replies, when will the administration be able to prepare those written replies? I think in a week we'll be able to give the reply. And after we have the written reply, we'll circulate the reply among members. And afterwards, we'll decide on the date of next meeting. Since we have already gone through the clause-by-clause study, we'll just follow up on the written reply and see whether we have any comment or we need any amendment. I think, Chairman, we can do it by circulation. If there is no need to call another meeting, let's just do away with another meeting. Okay. Anything else? All right, let me turn to the timetable. The deadline, if we completed the study on the 14th of July, we report to the House. I think the notice, deadline for notice, 7th of June, so we need to extend the deadline. Maybe we extend it to the 5th of July. Report to the House, 23rd of June. Any notice, 28th of June. I will, on the 7th of June, move a motion to extend the period of scrutiny of the regulation. Depending on the reply, we may decide on whether or not we have next meeting. All right, anything else? If not, then the meeting is adjourned. Thank you very much.